Okay, everyone. Welcome, Harry, Rebecca, Sari, and welcome to those who will be watching this video recording at some point. And in week 2, we begin to talk about the framework for judicial review. So in week 1, welcome back, Joshua. Thanks for coming as well. So you will recall in week 1, we started to talk about what administrative law is all about. And essentially, the main purpose of administrative law is to make sure that when the executive makes a decision which has an impact on citizens or individuals, there is an avenue for a review of those decisions. And oftentimes in the past, these reviews of administrative decisions was done by recourse to the courts, or what is known as judicial review. And however, starting in 1975, with the passage of the Administrative Appeals Tribunal Act 1975 Commonwealth, the Australian Commonwealth Parliament decided through that legislation to enable citizens to have their decisions reviewed by the AAT, which is an administrative tribunal. In other words, it belongs to the executive. It is not part of the judicial system. And also mainly because the AAT was not constituted according to Chapter 4 of the Australian Commonwealth Constitution. So the AAT is not part of the federal court system in Australia. It is, however, part of the executive, and in fact, it falls within the portfolio of the Attorney General of the Commonwealth. And we will start talking about merits review, I think, by next week. And we will later on learn that when you talk about merits review, the main advantage of merits review is that it enables the AAT, for example, or the administrative tribunal, not only to examine the legality of an administrative decision, but it also enables the Administrative Appeals Tribunal to look at the merits of an administrative decision. In other words, the AAT can review the factual correctness of a decision. It can also examine the correctness in the exercise of a discretion which might have been given to an administrative decision maker. And more importantly, when it comes to merits review of decisions, the AAT has the power to remake a decision of the original decision maker. So in other words, it can, because the Administrative Appeals Tribunal steps in the shoes of the original decision maker, the AAT has the power to actually, come up with a thoroughly new decision. When you speak of judicial review, for example, hello, Tim, thanks for joining us. Let us be clear that, apart from the fact that judicial review is limited to an examination or a review of the legality of an administrative decision, which means, therefore, the focus is really on, whether or not the decision is legal or not. And it has, it would be beyond the scope of judicial review to examine the merits of a decision. So in other words, courts undertaking judicial review cannot examine the factual correctness of an administrative decision, nor can courts review whether or not the discretion made by an administrative decision maker was, the proper one to have been made under the circumstances, because that would be merits review. So there is a very limited scope when it comes to judicial review. So judicial review is of a very limited scope when it comes to a review of administrative decisions. It focuses only on the legality, but at the same time, judicial review is limited only to the quashal. So in the event that a court determines that a decision was not made according to the law, courts cannot remake a decision. They can only quash a decision, or perhaps remit an administrative decision back to the original decision maker, so that it will now be the original decision maker who can, remake the decision. But courts cannot remake an administrative decision, even if it makes a finding that the decision was not made according to the law. So that is a crucial point we should be making once we start talking about judicial review. So I hope that was clear. Any questions so far before we start delving into the framework for judicial review? You can ask a question about, this particular topic or the topic we had last week, or any question in relation to our unit. And remember that this is recorded, so you always have the chance to go back and have a look at the recording, because I will upload the recording to YouTube tonight. Any questions so far or any comments before we proceed? Okay, very good. So if you happen to have any question, feel free to unmute yourself or send me a question or comment through the chat box. Okay, very good. So tonight, our purpose for having this tutorial in relation to topic 2 is that after studying this topic, you should then be able to discuss and explain the concept of judicial review and when it is available to review administrative decisions. So let us be clear that when we talk at this point about judicial review, we're mainly talking about federal judicial review or Commonwealth judicial review. We're not looking at state judicial review. So for those who were here last week and for those who had the chance to go through the recording, I had pointed out that when you speak about state judicial review, because in the states there is no separation of powers between the courts and the executive or the legislature, given that in the states there is a supremacy of the parliament. So in other words, state courts cannot invalidate a state law because of parliamentary supremacy, unless the state law violates the Australian Commonwealth Constitution. But in general, state courts cannot invalidate state laws. And for that reason, it is also commonly understood that because of the absence of a separation of powers in the states, then it is permissible for a state court to actually also examine the merits or the factual correctness of an administrative decision. That can't be done at the federal level because, as we said, there is a partial separation of powers at the federal level. So courts are insulated from the executive and the parliament. So if you did a little background of constitutional law, you would have been aware that there's a partial separation of powers in the Westminster system of government, such as the one in Australia, mainly because the ones who are running the executive, such as the Prime Minister and his cabinet, they actually belong to the parliament. So you can easily say that the executive, that the Prime Minister and his cabinet, and because they control the parliament, they can actually determine what the legislative agenda is, and that's what they do all the time. And so there is no separation between the executive and the legislation. And for that reason, given the partial separation of powers in Australia, the courts, therefore, at least the federal court system, has a very important role in ensuring that there is some kind of checks and balance in the constitutional framework in Australia, and which is why the courts, following, for example, the case of the Boilermakers case, is very clear that the courts will not allow that the parliament, for example, provides power to the judiciary which does not involve the exercise of judicial power. And so federal courts will not tolerate any law passed by the Commonwealth Parliament that would allow the federal judiciary, for example, to examine the factual correctness or the merits of administrative decisions. So the federal courts have been quite clear that they will only review the legality of administrative decisions. Okay, so as I was quite clear in pointing out, when you have this topic, for example, in relation to topic 2, we're looking at Commonwealth or federal judicial review, not state judicial review. Now, at the same time, after studying this topic, you should be able to discuss and explain the framework and legal basis for judicial review in Australia, the requirements of justiciability in judicial review, the instances when an application for judicial review under the Judiciary Act of 1977 can be made, the jurisdictional requirements of the Judiciary Act, and what decisions are covered under the Judiciary Act, and finally, what is meant by decisions. Now, as I pointed out, we do have, as part of our assessment, we do have weekly online quizzes, and these 10 quizzes comprise 10% of the final grade, and each weekly quiz is equivalent to 1% of the final grade. And there will be some group work in the sense that what I'm hoping to do is that before you try to answer the quiz, I'm hoping that you actually take the time to have a look not only at the lecture notes that we have and the lecture podcast, but also the weekly tutorials that we have, because during the weekly tutorials, I will also examine the online quiz. I will not provide an answer to the online quiz, but the tutorials will provide a forum for us to illuminate some of the key concepts that are actually being assessed in the online quiz. So whatever key concepts are there, the tutorial will be used for us to elaborate on and illuminate some of the key principles that are assessed in the online quiz. So moving on, if there are no questions at the moment, let's have a look at the tutorial question, and I will highlight for you, or you could highlight for the rest of the class, what seem to be key principles of administrative law. Can I have a volunteer to read tutorial, the quiz question for us? We're not answering the quiz, but my purpose is to highlight some of the concepts, and we will go through those concepts in the course of this tutorial. Can I get a volunteer to just read the quiz question? Any volunteer? Sari, can you do us the honors? Just to read the quiz question.
Yeah. Can you hear me?
Hang on. You're gonna have to unmute yourself. Okay. I think you're
Can you hear
unmuted,
me?
but I can't
Can you hear
hear
me? Oh, sorry.
There's something wrong with your mic. Can anyone else hear? Can anyone hear Sari?
Hello?
Who was that?
Yeah.
Oh, Rebecca could hear Sari. How come I can't hear Sari? But I heard Rebecca, I think, earlier. I don't know. Was that could have been Sari? I got confused. Sari, can you try saying something?
Yeah. Hello, can you hear me?
Yes, I could. Very good. Thank you. Very good.
Okay. All right. So John Goodwin entered into a contract of services amounting to $475,000 with the Australian Government Department of Home Affairs to develop a key component of the software security system of the department. The Minister for Home Affairs exercised his non-statutory executive power in entering into the contract. After completing the project, Goodwin billed the department for the unpaid balance under the contract. However, the department refused to pay on the grounds that the project did not meet the required specifications under the contract. Goodwin has approached you, a solicitor for legal advice. He wants to know if he can apply for judicial review under the Judicial Decisions Review Act 1977 against the decision of the department. Which answer is the most correct?
Thank you. Can you go through the answers as well, if you don't mind?
Okay. Yeah, that's fine. He can apply for judicial review since the non-payment involves a factual question and is apt for a merits review. He can apply for judicial review under the ADJR Act since the decision was based on an enactment. He cannot apply for judicial review under the ADJR Act since the decision was not based on an enactment. He cannot apply for judicial review since he has no legal standing, and all of the answers are wrong.
Okay, thank you, Sari. Thank you. So, would anyone care to highlight some of the key questions? I mean, some of the key concepts. I wish I could. Would anyone wish to do that? The crucial point here with this particular quiz is the fact that in entering into the contract, the Minister for Home Affairs, who obviously is part of the executive, has exercised his non-statutory executive power. So let's be clear about that. So when it comes, for example, to members of the executive, it could be, ministers, department heads, and so on, the basis for their ability to act or to exercise their executive power can be based on the Constitution. In other words, Section 61 of the Australian Commonwealth Constitution is quite clear that the executive power is exercised by the executive, for example. And so, in other words, there is a constitutional basis for the exercise of executive power, and that's under the Constitution. That is crucial. That's an important point, because what if you don't have a constitution? Does it mean, therefore, that you cannot have an executive power? So in most other countries, if you look at the United States, there is a US Constitution. And again, it's quite clear that the that there is a constitutional basis for the exercise of executive power because it is in the US Constitution. But how about jurisdictions such as the UK or New Zealand, where they don't have a written constitution? What then is the basis for the Prime Minister and his cabinet exercising executive power in the absence of a written constitution? At least in Australia, because of Section 61 of the Constitution, we know that there is a legal or a constitutional basis for the exercise of executive power. It's Section 61. So let's be clear about that. So one of the legal sources or the legal basis for the exercise of executive power is actually, in Australia at least, it is Section 61 of the Australian Commonwealth Constitution. But at the same time, the other legal basis for the exercise of executive power is what is known as the exercise of prerogative powers or inherent powers of the executive. So in other words, in the UK and in New Zealand, even in the absence of a written constitution, it is understood that you cannot have a government without the executive, because the legislature passes the laws, somebody has to execute the laws. It has to be the executive, and so therefore it is understood in constitutional governments that there is a body that has to exercise the executive power. So it is understood that the executive, inherent in the executive, would be certain executive powers. And these inherent executive powers are also related to what are known as prerogative powers. So that's the power of the Prime Minister, for example, to enter into treaties, or the power of the executive to enter into treaties, the power of the executive to enter into contracts, or to perhaps pardon, convicts, and so on. So these are all part of the executive power. Even the power to have a police force. These are known as inherent powers of the executive, even in the absence of a written constitution. So we've talked about the Constitution as a source of executive power. We've talked about the inherent or the prerogative powers of the executive. A third source of executive power is actually based on statutes. So what often happens is that the Parliament, or in the case of Australia, the Australian Commonwealth Parliament actually delegates certain powers to the executive. So there can be a statutory basis for the exercise of executive powers. Now, as we later on see, and I wonder if I'm beginning to answer the question now. So, and I'm going to avoid doing that for now. But so it should be clear that the quiz pointed out that the Minister for Home Affairs exercised his non-statutory executive power. Keep that in mind, because when we look at the Administrative Decisions Judicial Review Act of 1977, the course of the other tutorial questions, we will learn a crucial point as to what type of administrative decisions can be reviewed by the courts under the ADJR Act. Okay, so keep in mind, as far as the quiz is concerned, this involves the exercise of non-statutory executive power. I shall not say more in the meantime because I might end up answering the quiz. Okay, let's go to quiz 1. Can I get somebody to read question 1 for us? A volunteer to read tutorial question 1? Joshua, perhaps, or Tim? Josh? Oh, okay, your kids are noisy. Okay, then. Okay, so soon. Okay, Tim, do you mind, if you're there, do you mind reading a question for us? Or Harry? Rebecca? Otherwise, I'm going to pick Sari again, and I hope Sari will not think that, I'm causing too much trouble.
Yeah, okay, so after years of working as a disability support worker, Sharon Hills decided to set up her own business providing support to disabled persons. The Disability Support Workers Act of the Commonwealth requires that operators, owners, or managers of businesses seeking to provide services to persons with disabilities must have a business license from the Australian Department of Social Services. Such a business license may be given only to persons who have had professional experience as a disability support worker for 5 years and who are of good moral character. The Act also provides that an application for a license must be made not later than June 30 of the same year. Sharon applied for a license on the 18th of June. However, staff of the ADSS did not accept her application because her documents showing her years of professional experience as a disability support worker were incomplete. She returned on the 27th of June, Friday, to submit further documents, but these were still considered incomplete, and so her application was not accepted. On 30th of June, she returned with the complete set of documents on her professional experience, but was then asked to provide further evidence relating to her good moral character. She returned the next day, or July 1, to submit the necessary documents, but the ADSS refused to accept her application because it had been submitted after the deadline. Sharon is frustrated and angry that her application was not accepted and has come to you for legal advice. Assume that resource to the Administrative Appeals Tribunal is not available. Advise Sharon on whether judicial review was available and why.
Okay, thank you. Would anyone wish to attempt to answer tutorial question 1? Any attempt? Anyone wishing to do an attempt? Okay. There doesn't seem to be one.
Menu.
Oh,
sorry, it's Josh here.
Benji, thank you, Josh.
I don't want to attempt to answer the question. I just wanted to quickly, I don't know whether we can open up for discussion on the idea rather than attempt a question, but a staff person would not be part of the executive, though. Would that have anything to do with an issue with going to the?
A staff person would not be part of the executive. I'm not sure I understand that.
I must have a different train of thought, but I assumed I've had to go and come back again. But judicial review only deals with the executive.
Okay.
With the administrative appeal.
Josh, I lost you there. Okay, so I think he lost his internet connection. That would have been an interesting point. We'll try to chase what Josh had in mind when he gets back, because he did talk about somebody being a staff. So we'll get Josh to elucidate on what he was trying to say. But otherwise, I'll get back to that if Josh is unable to join us very soon. Okay, so the crucial point here is that the decision by the ADSS. Okay, so the decision by the ADSS was actually based on. Oh, Josh is back. Josh, you're back. Do you want to continue with what you were saying earlier? Okay, so we'll give Josh a chance later on, because he seems to have a problem with the audio. I'm going to address, I think, the crucial point that Josh was making, and I'll get back to that in a short while. So, but going back to tutorial question 1, because this is a very crucial point as far as the Judiciary Act is concerned, we will notice that a decision was actually made in relation to the application of Sharon, for a business license. The decision was made based on the Disability Support Workers Act Commonwealth. Okay, so the Disability Support Workers Act requires that somebody like Sharon must have a business license. And so therefore, if a decision was made not to give Sharon a license, such a decision would have been based on the Disability Support Workers Act. So the Disability Support Workers Act Commonwealth is considered an enactment because it is an enactment coming from the Commonwealth Parliament. Now that is a very crucial point, because for the purpose of the application of the ADJR Act of 1977, okay, let me be clear. In relation to judicial review under the Administrative Decisions, Judicial Decisions Review Act of 1977 Commonwealth, the administrative decision for it to be subject to judicial review under the ADJR Act must have been based on an enactment. Okay? So in other words, if an administrative decision was not based on an enactment, for example, the decision was based on the exercise of executive power under the Constitution, under Section 61, or it could have been or the administrative decision was based on the exercise of inherent or prerogative powers, then in that case, the ADJR Act does not apply. Okay, so let me repeat. And I will discuss the difference between judicial review under the ADJR Act and judicial review, for example, under common law judicial review, or perhaps even under Section 75(5) of the Australian Commonwealth Constitution. So we're going to discuss that. So this is a crucial point. Let me begin, however, first with a little discussion about the ADJR Act. So in the past, there were at least 3 kinds of judicial review. One was common law judicial review. So even in the absence of the ADJR Act, many years ago, courts in Australia had already asserted their right to police the exercise of executive power. And that is known as common law judicial review. Okay, so in that case, for example, common law, courts of the Commonwealth felt that they had the power to issue prerogative writs such as certiorari, prohibition, mandamus, or even habeas corpus, or the equitable remedies of injunction or declaratory remedies to determine or to say that an action or a decision of the executive was within the law or against the law or contrary to the law. So that is what is known as a common law judicial review. Even in the absence of a statute, courts asserted their power to be able to police the exercise of executive power. And you can trace this in the 1300s when there was a battle between the courts and the king, where the court said that the king, even if he was monarch, was subject to the rule of law. And when the monarch, therefore the king, exercised his powers in a way that was contrary to the rule of law, then courts had the power to say that what the monarch did was unlawful or illegal. So there is a common law judicial review. There is a second source of power for judicial review, and that is according to the Constitution. So if you look at Section 75(5) of the Australian Commonwealth Constitution, that constitutional provision provides that the High Court, in all matters where there is a prayer for the issuance of a writ of prohibition, mandamus, or an injunction against an officer of the Commonwealth, then the High Court has original jurisdiction. So we've now talked about the common law judicial review. We've talked about a constitutional basis in relation to the High Court, which is Section 75(5) of the Australian Commonwealth Constitution. But there is a third source of the power of judicial review, and that is based on statute. Before we talk about the ADJR Act, for example, if you look at the judicial, I'm getting dizzy because I'm getting hungry now, sorry. So if you look at the Judiciary Act of 1903 Commonwealth, or is it because of the change in from it being daytime to nighttime, it makes me sleepy, it makes me dizzy. So if you look at the Judiciary Act of 1903 Commonwealth, Section 39B, it provides that the Federal Court of Australia has the power to issue writs of mandamus, prohibition, or injunction against an officer of the Commonwealth. And that particular provision is actually similar to Section 75(5) of the Australian Commonwealth Constitution. Okay, but because it is the Judiciary Act of 1903 Commonwealth, you see that the basis is actually a statute. So it is the Commonwealth Parliament which authorized the Federal Court of Australia to have the power of judicial review in relation to decisions made by the executive, particularly in relation to officers of the Commonwealth, but only in relation to the issuance of writs of mandamus, prohibition, or injunction. So we will see, therefore, when you look at Section 39B of the Judiciary Act of 1903 Commonwealth, and when you look at Section 75(5) of the Australian Commonwealth Constitution, we will see that the power of judicial review in relation to the judicial remedies is very limited, because it is limited to mandamus, prohibition, and injunction. The advantage, therefore, of the Administrative Decisions Judicial Review Act of 1977 Commonwealth, which is again a law passed by the Commonwealth Parliament, which provided for another avenue for judicial review. The beauty of that is that there is now greater scope for powers of the federal judiciary to review decisions of the executive, and they've also expanded, as we later on see, the grounds for judicial review. So in other words, the key point there is that if you were going to be a lawyer and you advised your client about potentially having a decision made by the executive to be reviewed, you would wish for such a review by the judiciary to be made under the Administrative Decisions Judicial Review Act, mainly for two reasons. One, there is broader power on the part of the judiciary to provide remedies, as opposed to just the Section 39B of the Judiciary Act or Section 75(5) of the Constitution, which provided only the remedies of prohibition, mandamus, and injunction. There are more remedies as far as the ADJR Act is concerned. Okay, but at the same time, the ADJR Act of 1977, in a sense, codifies the possible grounds for judicial review, because as we examine later on, there are now multiple grounds for judicial review, including, the violation of the rights of natural justice, whether or not a decision was made according to statute, and so on. So there are more grounds. So given an opportunity, you would wish that a judicial review be anchored on the ADJR Act of 1977 Commonwealth. Okay, so we're clear? We've made a distinction. The problem, however, with the ADJR Act is that for judicial review to be made under the ADJR Act, the requirement is that the administrative decision must have been based on an enactment. Are we clear? So in other words, if an administrative decision was not based on an enactment, then you cannot have judicial review under the ADJR Act. So in other words, if a decision was made by the executive on the basis of the exercise of its prerogative powers, so for example, what we need to remember is that the executive can enter into contracts, correct? Even in the absence of an enactment, we recognize that the executive has inherent power to enter into contracts. It could be the contract to buy services or to purchase goods. It could be the contract to, appoint somebody for a position. But even in the absence, in other words, even in the absence of an enabling law or a statute passed by the Commonwealth Parliament, we know that the executive has certain inherent powers. So when the executive therefore exercises his or her inherent powers outside of having a statutory basis, then in that case, any decision made by the executive in the exercise of his inherent powers, meaning he is not exercising statutory powers, there can be no recourse to the ADJR Act. So in relation to the ADJR Act, you can only have a review of administrative decisions under the ADJR Act if the administrative decision was based under an enactment. Are we clear? So from Josh, so as the decision not to accept the application was based upon the guidelines of the DSWA, then judicial review is available. That is correct. So that's correct, Josh. Because the decision was based on the Disability Support Workers Act, which is an enactment, then you can have judicial review. Okay, so that's clear. Now, however, and I was making that clear just for the purpose of the quiz, okay? But when you actually have an exam, in the exam or in a major assessment, there are actually 5 requirements that must be met for a decision to be reviewed under the ADJR Act. One of them is that there has to be a decision or a failure to make a decision. And we will have an examination of what the decision is when we examine the case of Australian Broadcasting Tribunal versus Bond. Because not every decision is in fact a reviewable decision. Okay, are we clear? So it might be an administrative decision, but not every administrative decision is a reviewable decision. So for example, you go to an administrative officer in this case and you say, the staff member of DSS says, no, you're asking for an extension of 1 day. I can't give you that extension. There is a decision not to give an extension of 1 day, correct? But that is not a reviewable decision. In other words, you can't run to the courts to ask for a review of the decision not to grant an extension of 1 day. Or it could be that there is a hearing before an administrative officer, such as because there could have been a violation of some consumer laws, and you wanted to ask the hearing officer allow you to bring in a lawyer to represent your interests, and the hearing officer says, no, you cannot have a lawyer. There is a decision not to grant you a lawyer, but is that a reviewable decision? And we will learn later on, which is one of the questions we have, that for there to be a reviewable decision, that decision must be operative. In other words, it has to affect a right. It must be substantive. In other words, it cannot be procedural. So an example of a procedural matter would be one, whether or not it should be given a lawyer, or whether or not there should be an extension. So we're gonna get into that later on. So there are these 5 judicial requirements you must have in order for there to be recourse to judicial review under the ADGR Act. One is that there has to be a decision. 2, a person must be aggrieved by a decision. Okay, so here we know that Sharon Hills is aggrieved because she lost her right to have a business license. And because she does not have a business license, she cannot operate and provide services to persons with disabilities. So she is aggrieved. Now imagine if Sharon Hills talked to her friend and said, I'm not really good in terms of going before the DSS. Can I just ask you to represent me? And in that case, if that friend were to appear before the DSS, that person would not have been aggrieved because that person has no right or interest in the matter. So a person is aggrieved if that person's rights or interests or legitimate expectations are breached or impaired or violated by a decision of the executive. So we're clear? So we've talked about that there has to be a decision. It must be final, operative, and substantive, following Australian Broadcasting Tribunal versus Bond, which we discuss later on. The person must be aggrieved. Thirdly, the decision must be of an administrative character. And I guess the point of Josh earlier was that since the decision was made by a staff of the ADSS, I think this is what I understood earlier, was that a decision, was that an administrative decision? And the answer for our purpose of the quiz is that yes, it is an administrative decision, for the simple reason that one way of determining whether or not a decision was administrative or not is to ask yourself, is that a judicial decision? Is that a decision made by the judiciary? It is not. Is it a legislative decision? In other words, it is a decision, for example, made by the parliament. We know it is not. So if it is not an executive, if it is not a legislative decision, and it is not a judicial decision, then by process of elimination, that has to be an executive decision. And what we need to know is that oftentimes when it comes to decision making within the executive, it is permissible for the minister or the head of a department to actually delegate decision making. And the delegated power or authority to make decisions down the line is still considered to be a decision made by the executive. I think that was the question of Josh. So here, when it, in relation to the, Josh, yes?
Sorry, I was going to just expand upon what you said just then. If the dates were to say no new application could be submitted after June 30 or after July 1, and the staff member said, no, you're too late because it's July 1, but she'd already had an application in, then that decision would be done by the staff member and not by technically the Act or the executive. So then it wouldn't be judicial review. Is that correct?
No, it would still have been. It would still have been under the under the enactment, because in that particular instance, Josh, if the ADSS staff had turned down or had refused to accept the application because, according to her, it was submitted late, that staff member would still have made that decision on the basis of the Disability Support Workers Act. It was her interpretation of the act. So, in other words, the decision of the ADSS staff in rejecting, the submission of the document because it would have been submitted late was still in pursuance of the enactment. And because it was made in pursuance of the enactment, the decision still was made under an enactment. And therefore, the review could be made still under the Administrative Decisions Judicial Review Act of 1977.
Thanks.
Okay. So are we clear? So we've talked about there has to be a decision which is final, operative, and substantive. We've also said that a second jurisdictional requirement for a judicial review to be made under the Judiciary Act is that the person has to be aggrieved, meaning somebody has legal interest. Third, the decision must be of an administrative character, and more importantly, the decision must have been made under an enactment. So an enactment in this particular case would be an act passed by the Commonwealth Parliament, or it could be an instrument. An instrument would be one like a rule or a bylaw or a regulation that is then crafted by the executive in pursuance of an enactment. It is what is known as subordinate legislation. That is still considered an enactment. So an enactment is the one passed by the Commonwealth Parliament. What oftentimes happens is that the Commonwealth Parliament authorizes the executive to come up with the rules, guidelines, or bylaws or policies in implementation of the primary legislation. Because the Commonwealth Parliament, for example, feels that it is the executive which has the expertise or the skills or the ability to thresh out the details of the Commonwealth Parliament, of the statute. So in that case, an instrument would be passed by the executive. So you will see this in the form of policy decisions, memoranda, bylaws, rules, or regulations. These are called instruments. But because these instruments were crafted or written or drafted by the executive in pursuance of an enactment, the primary legislation, they're still considered under an enactment based on the Judiciary Act definition. Okay, so there is a fourth comment: the decision must have been made under an enactment, including an instrument crafted on the basis of an enactment. And finally, the decision must not have been a decision which is made by the Governor General, or a decision included in any of the classes of decisions set out in the schedule. So, for example, decisions made by the ASIO, Australian Security Intelligence Organization, cannot be the subject of a review by the Judiciary Act. Decisions made by the Cabinet also cannot be subject to review by the under the Judiciary Act, and so on. So, are we clear?
So, Manyo, just on that, the New Zealanders that are getting sent back to New Zealand, they've lived here forever.
Yeah.
If, the Cabinet, which is Dutton, if he was to make a decision which is outside of the legislation of sending them back, the Immigration Act, that would not or would be able to be reviewed if he made a decision outside of the Act?
That's a very good question. And Josh, before I answer the question, can I just, so that's my problem sometimes. If I'm given a question, I tend not to give a straightforward answer. I need to explain. Would that be okay?
Sure.
Okay, good. So that's a very important and relevant question to us, because as pointed out by Josh, a lot of New Zealanders have actually been living here since they were kids. They don't happen, a lot of them, they're not Australian citizens, they're New Zealand citizens, and their ties are in Australia, they don't have ties in New Zealand. But because they committed certain crimes of more than 1 year, they've been imprisoned for more, or convicted with imprisonment for more than 1 year, then they have to be ejected. There is an option on the part of the Australian government to kick them out of Australia. Now, so what if the Department of Home Affairs Secretary or Minister Peter Dutton decides that this particular New Zealander, who is not an Australian citizen, has to be ejected, has to leave Australia, okay? So as pointed out correctly by Josh, the first question we need to ask is, when Minister Dutton makes a decision, did he make a decision on the basis of the Immigration Act of 1967? Or did he make a decision on the basis of the exercise of his prerogative powers? Because part of the prerogative powers is the power to exclude aliens. So for example, when you have the boat refugees, in many instances, the decision of the minister not to allow them to enter into the shores of Australia is not based on the Immigration Act of 1967. It's actually based on the exercise of prerogative powers, which means the power of the executive to exclude aliens from the territory of Australia. So that is the first question we need to ask. Was the decision made on the basis of the Immigration Act, meaning a statute or an enactment, or was it on the basis of the exercise of the inherent powers of the executive? Now, in relation to that particular question, I don't really know the facts. I would think that in many instances, in relation to the New Zealand citizens, the decision by Peter Dutton to exclude or to expel these New Zealand citizens who were convicted criminals, I think the decision was made actually on the basis of the Immigration Act, because it is on the basis of the Immigration Act that it provides that aliens, or not really aliens. I don't think that's a correct term, because an alien is somebody who doesn't have any proper visa to Australia. So under the Immigration Act of 1967, which is an enactment, therefore, what it provides essentially is that the Australian government has the power to exclude or from the Australian territory, or to expel from Australia those individuals who have the non-Australian citizens who have been convicted of crimes where the punishment is imprisonment of 12 months or more. And so because, if my factual understanding is correct, because the decision of the minister was based on the Immigration Act, then recourse to the Administrative Decisions Judicial Review Act of 1977 is the proper recourse, because it was made on the enactment. Now, having said that, however, what we also need to point out is that it is very possible that a decision, that a particular legislation will actually provide that we'll have what is known as a privative clause, which will actually say, therefore, that when the Minister for Home Affairs, for example, determines that somebody should be a non-Australian citizen, should be expelled from Australia, that decision cannot be the subject of judicial review. That potentially can prevent a decision from being reviewed under the ADGR Act because of the privative clause. Okay? Now, the question then is, if there is a privative clause, would it mean, therefore, that there is no longer any scope for judicial review? And the answer is no. Because we will recall that under Section 75(5) of the Australian Commonwealth Constitution, as well as Section 39B of the Judiciary Act of 1903 Commonwealth, the High Court in relation to the Constitution and the Federal Court of Australia in relation to Section 39B of the Judiciary Act of 1903 have the power to issue writs of mandamus, prohibition, or injunction in relation to officers of the Commonwealth. So an example of an officer of the Commonwealth would be the Minister for Home Affairs. So what has in fact happened is that in those instances, when there is a privative clause in the Immigration Act, what the lawyers of immigrants would then do is to seek recourse under either Section 75(5) or Section 39B of the Judiciary Act of 1903. But in that case, they are limited to the judicial remedies of mandamus, prohibition, or injunction, which we will examine later on. But an example of prohibition or an injunction would be for the court, either the High Court or the Federal Court under Section 39B of the Judiciary Act of 1903, to prohibit a minister from expelling an immigrant. So that has been done. Okay, so that's a long-winded answer to what would otherwise have been a very simple question. Okay, questions so far? We're good. Okay, so we'll leave that for now. So we've answered that question, I think, fully. Now, question 2, and we're kind of running out of time. Questions? Question 2. Can somebody read question 2 for us?
Sure.
Thank you, Josh.
The Australian newspaper reported that a federal government commissioned report had detailed widespread and systematic abuses of boat refugees in Australia's refugee facility in Manus Island. The Australian Refugee Consortium, an Australian non-government organisation, asked the Minister for Immigration and Border Protection who commissioned the report to publish it, but he refused. The consortium has approached you for legal advice on whether it has valid grounds to apply for judicial review of the Minister's decision not to publish the report. Give your advice.
Okay, thank you, Josh. Would anyone care to take a crack at the question? Okay, so the answer here is if I were the solicitor, in this case, asked to provide legal advice, I would advise the Australian Refugee Commission not to seek judicial review of the decision for two reasons. One, the decision by the minister not to allow the publication of the report on the status of the refugees in Manus Island would have been considered a political decision. So it is a political decision in the sense that it involves a political and a policy decision on whether or not it should be released. It is a political and a policy decision because it has implications on the susceptibility to the Australian government being embarrassed by the report, potentially being subjected to legal processes or even lawsuits. So it is a political decision. It is also a political decision because the question of whether or not it should be released is not based on a legal standard. You know, what is the legal standard for the court to apply whether it should be or should not be released? There is no legal standard for that. So ultimately, therefore, it is a political question whether or not it should be released, and that depends ultimately, therefore, on the wisdom or the lack of it of the executive. So that would be reason one. I would, as a lawyer, I would suggest, I would advise the Australian Refugee Commission Consortium not to apply for judicial review because it is a political decision. And if it is a political decision of the executive, it is non-justiciable. Courts will not stop, will not accept the exercise of jurisdiction over such a matter because it involves a political question. The second ground why I would advise the Australian Refugee Consortium from asking for a judicial review of the decision not to publish the report, the second reason would be that the ARC does not have a locus standi because it has no legal right to the report. It has not been affected by, it is not the subject of systematic abuses because it is not a boat refugee. And if you look at the case of Onus versus ACOA and McBain, ex parte Australian Bishops Conference of Australia, we will see that a legal requirement for judicial review to be applied by an individual is that that person must have legal standing or locus standi. And there can only be legal standing or locus standi if that person who's applying for judicial review can identify a right or interest in the subject matter. Here, ARC cannot. So there is no legal standing on the part of the ARC, therefore it shouldn't be applying for judicial review. Questions? Okay, so none. Okay, let's go to tutorial question 3. Can I get somebody to read question 3 for us? And by the way, I will publish the answers to the tutorial questions. I'll post them in Moodle. If not tonight, tomorrow morning. Okay, tutorial question 3. Can somebody read question 3 for us, please?
The Stellar Innovations won a multi-million-dollar government contract in 2010 to build and maintain certain infrastructure projects as part of a Fast-Track Infrastructure Stimulus Act 2010. However, when Stellar Innovations sought to bill the federal government for a portion of the project that had been completed, the Minister for Infrastructure and Regional Development refused payment. The minister asserted that the contractor failed to comply with the key conditions of the contract. After the minister refused to reconsider his decision to refuse payment of the contract, Stellar Innovations approached you for legal advice. The contractor wants to know if it can ask for a judicial review of the minister's decision under the Administrative Decisions Judicial Review Act.
Thank you. Okay, sorry. Would anyone wish to provide an answer to that question? This question is actually tricky. I have to warn you in advance. It is a tricky question. Would anyone care to try and answer. Okay, so the reason why this is tricky is that we know that the Stellar Innovations Proprietary Limited won the contract, and that contract was on the basis of an enactment, which was the Fast Track Infrastructure Stimulus Act of 2010. So there is an enactment in relation to contracts, but in relation to the refusal of the minister to pay under the contract, the minister refused to pay the contractor because the contractor failed to comply with a key condition of the contract. So in other words, here, in relation to the refusal of the minister to pay the contract, it was because of a failure of the company, Stellar Innovations, to meet a key condition of the contract. In other words, how then do we know, what is then the basis of the minister saying that a key condition of the contract was not fulfilled? And what law governs whether or not a key condition of the contract had been breached? The answer is that, you know, the question of the legality of the minister's actions on whether or not he had the legal basis to refuse payment will not be determined by the Fast Track Infrastructure and Stimulus Act of 2010, but by the general rule of contracts. Okay, so while the contract may have been entered into as part of the Fast Track Infrastructure Stimulus Act of 2010, the refusal of the minister to pay under the contract was actually based on the general laws of contract. So if you've taken up the law of contracts, you know that there is contract law in Australia, and much of it is on the basis of the common law. And if the decision, therefore, of the minister to refuse to pay the contract was based on the general law of contracts and not based on the Fast Track Infrastructure Stimulus Act, then that decision to refuse to pay was not made under an enactment, but was in fact made on the basis of the general laws of contract. And that is a crucial point, because if you examine Griffith University versus Stan, as well as Australian National University versus Burns, the High Court has been very clear that not all decisions which affect an individual, not all on the basis of an administrative decision, not all administrative decisions are actually made on the basis of an enactment, but actually on the basis of a general law, such as a general law of contract. Okay, but for there to be recourse under the ADGR Act, it has to be clear that the refusal would have been made on the basis of the enactment itself. But in this case, the refusal was based on the general laws of contracts. And so following the case of Griffith University versus Stan, there can be no recourse under the ADGR Act because the decision was made not under the enactment, but on the basis of the general law of contracts. Was that clear? So because we're running out of time, let's just go back to the quiz. Okay, so you will recall that here, in relation to the quiz question, quiz 1, we know from the facts that the Minister for Home Affairs exercises non-statutory executive power. So we know the effect of that, right? If you will recall, you know, review. So it's based on non-statutory executive power. So because the decision in this particular quiz, the executive power was based not on a statute, but the exercise of, because there is no enactment, as pointed out by Sari, but the executive decision was based on the exercise of an inherent executive power. The question is, can there be recourse to the ADGR Act? You should have the answer by now. And we also know that as far as judicial review is concerned, you know, we know that, well, I'm not going to do it in this point, at this point, because I've already discussed that point. I might answer the question, but we know that there is a difference between judicial review and merits review. We've also talked about a person needing to have legal standing. And would John Goodwin have legal standing? He entered into a contract, he was not paid. Does he have legal standing or not? Has his interest to be paid been violated or not? So that should be clear and apparent to you. I'm hoping that, you know, that would be an easy quiz question to answer. Okay, so I need to let you go. I think some of you are going to have your own tutorials. I'm going to have my own dinner. Any questions before we end tonight's tutorial? Yeah, very good. I think Josh got it right. Okay, so Josh has our Contracts B tutorial. So thanks, everyone. I'll see you again next week. And, hopefully you shouldn't have to end up with a wrong answer to the quiz. Good night, everyone, and thanks for joining me. Bye.